Good afternoon and welcome to the webinar. We're thrilled that so many members of the profession could join the webinar today on the new competency profiles for patent agents and trademark agents, recently published by the College of Patent Agent and Trademark Agents, or CPATA. Before we begin the webinar, I will deliver the land acknowledgement. The Intellectual Property Institute of Canada, or IPIC, its office is located in the city of Ottawa, Ontario, on the traditional unceded territories of the Algonquin Anishinaabe people. IPIC honors the Algonquin, Anishinaabe, and all First Nations, Inuit, and Métis people for their important contributions to this land and to the fields of intellectual property, traditional knowledge, and cultural expression. I am pleased to announce today's speakers. Representing the college, Leonora Hoyka, Judah Streszczynski, and Jennifer Slobodkin. I apologize, Judah, if I mispronounced your name. Leonora is a member of the CPATA board. She has over 35 years intellectual property law experience in both private and corporate practice. She started with Rideout and Maybe in Toronto and then joined IBM Canada in 1993. With IBM Canada, she performed several global roles, including managing patent and trademark portfolios and leading IP transactional teams. Subsequently, as Associate General Counsel with IBM Corporation in New York, she's IBM's Chief Trademark Counsel for over a decade and led IP law teams supporting IBM's Watson business unit, developing AI technologies, and IBM's global patent enforcement and licensing team. She is a registered Canadian patent and trademark agent and a past president of IPIC. Judah is a lawyer and frequent speaker on legal services, regulation, and practice. He is the CEO and Register of CPATA. He was previously Director of Practice Pro, LawPro's Claims Prevention and Risk Management Initiative, where he led its claims prevention, resource development, continuing professional development programming, and educational outreach efforts. Before joining LawPro, Judah was policy counsel at the Law Society of Ontario, advising on key issues facing the legal professions, including access to justice, professional regulation, and consumer protection issues. Jen Slobodkin is the Director of Registration and Education and Deputy Registrar at the College of Patent and Trademark Agents. She has almost 13 years of experience in professional regulation. She provides strategic and operational leadership, is responsible for ensuring compliance with CPATA's legislative framework in the areas of registration and education, and leads in the development of programs and strategies to ensure competence of licensees, which includes CPATA's multi-year competence initiative and administering the licensure process and qualifying examinations. I'm Carol Hitchman. I am a past president of IPIC and current chair of IPIC's Professional Regulation Committee, and I will be moderating today. Before we begin, I have a few housekeeping notes. Your audio output has been muted to avoid background noise. You're invited to submit questions using the Q&A button on your toolbar at the bottom of your screen. Please do not ask questions through the chat. Questions will be addressed at the end of the presentation. In compliance with accredited provider rules, IPIC is required to issue a participation code during the webinar. The code will be announced at some point during the presentation. Once the webinar has ended, you can go to ipic.ca/attestation to complete your attestation request. Once submitted, you will have immediate access to your attestation by logging into your portal and clicking on My IPIC CPD Attestations. Before I hand the microphone over to Judah, I know that fees are top of mind and of great concern to all patent and trademark agents, and I'm sure you're all aware of IPIC's objections and concerns. However, this webinar is about competency profiles, and so we have agreed with Judah that he will not be addressing fees in his opening remarks, but will take questions on fees at the end of the talk, time permitting. So Judah will now provide a high-level overview of who CPATA is, what they do, and why the competency framework development was so important and foundational for its work as a regulator. I will now turn the microphone over to Judah to begin the presentation.
Well, thank you so much, Carol, for that warm introduction. And thank you all for taking the time to join us today to learn about this really important step in the early days of the professional regulation of Canada's IP, trademark and patent agents. Thank you to IPIC. This is a wonderful example of collaboration between the professional association and the regulator. We were both planning education events about this topic. And when we found that out, we decided, why don't we pool resources and increase efficiency so that we could get this message out to agents as quickly and as effectively as possible. So we are grateful to IPIC for this and hoping for future opportunities to collaborate on education around professional responsibility and ethics. So again, my name is Judah Strivchinsky. I am honored to be the CEO and registrar of CPATA. I am thrilled to be part of an organization that is focused on building and growing the profession in the years to come. We are a small regulator that, as you probably know by now, has been given a mandate by Parliament to regulate patent agents and trademark agents in the public interest. So our mandate is beyond what IPIC and CPO used to do in terms of setting exams. We really are responsible for all aspects of professional regulation, competency setting, and professional development. It's a lot, and I'll explain a bit about some of the things we're working on. But just so you know, we're a pretty lean organization too. In our approach, we first off are a remote regulator. We don't have an office space. We don't have offices in Ottawa or elsewhere. We opened during the pandemic, and so our team is actually located throughout Canada. We have about 6 full-time staff, and we use expertise from outside where necessary, where appropriate. And we run a pretty lean shop. We do have a slight budgetary surplus that appears on our balance sheet, but that's only amounts that keep us going from January to March in the interim period before fees are collected for the annual licensing amount. So we don't have reserves, we have a tight budget, and we've got lots on our plate. So in terms of what's on our plate, we've been doing a lot to set the stage to make sure that we are able to meet our statutory obligations that were set by Parliament. First, one of the first things we did is we set a registry. And this has a registry of all the licensed patent agents and trademark agents so that the public can make sure that when they go and want to meet a professional, they know that this is not an unauthorized practitioner. This is somebody who has been licensed by the regulator. So this is an important aspect of public protection, and we're proud to have that available in both English and French on our website. We've also taken been passed the mantle with respect to the qualifying exams, and Jen is our subject matter expert lead in terms of the exam process, and we work with IP agents to continue the work that was initially done by IPIC and CPO, and are continuing to develop those exams. We also have set categories for licensees, and in new bylaws that just were announced, we've actually amended those slightly in order to better reflect IP agent practices, including in-house settings, where it wasn't clear where those in-house agents could be an active part of the profession if they weren't necessarily prosecuting work before CPO. So we've made some changes to enable and to be inclusive about our categories of licensing, so that those who come from alternate settings or from other settings who identifies patent agents and who are doing patent agent work can continue to do that in a license that fits their practice area. So we've been doing a lot in those areas that I would categorize more around professional development. But now we're also, as we're growing, starting to see more work around what I would categorize as professional regulation. We did the first early work around setting a code of conduct, which is available on our website. We did that in consultation with the professions and with the Federation of Law Societies to avoid duplication or extra confusion. We tried to make a code that would read pretty comfortably for those who might be regulated already, but also cover off the niche needs of the IP profession. We know it's not perfect. I've already spoken to IPIC's Professional Regulation Committee and advised them that we do have a running list of places where there likely will be consultation and opportunities for further development and refinement. And like any code of conduct, it's an evergreen project. And so we will be getting to it in due course. But first we needed to create one, and we need to educate people about its existence. And so that's our first stage. But beyond that initial foundation, we're also now starting to receive complaints. And while there was an initial hope that perhaps because in the past there hasn't been much knowledge of consumer dissatisfaction or concerns about IP agent practices, that we as the new regulator would not have many complaints or have to deal with this area very often. But it's early days and we can't bank on that fact. And in fact, we're already getting complaints in. And under our statute, we have to investigate. We have to take preliminary steps to determine what the allegations are, to understand what the complaint is, to investigate it, and if necessary, bring it forward to our investigation committee, and then if necessary, bring it to our discipline committee, which is effectively the tribunal that will hear these matters. So we're getting to that point now where we're getting towards hearings. And we're also at that point where we've been subject to our first judicial review on a decision made by CPATA around what was a preliminary quasi-complaint about an agent. And so we have our work cut out for us on the professional regulation side as well, as we knew would happen. And so we're beginning to get towards closer to full operation, where we're seeing both halves of the major parts of professional regulation happening together. We're building on the competencies, the standard setting, the cradle to grave education requirements that we will be exploring, but we've also had some complaints coming in. And so as we're building through to sort of our fuller scale, it's really important that we set the competency foundations right. And one of the gap areas before CPATA was that in recent memory, at least to my knowledge, nobody had done a professional assessment of sort of that Richard Scarry question, what do people do all day? What is it that patent agents do all day? What is it that trademark agents do all day? In most professions, there's something called a competency profile, which we'll learn about today because that's what we did. We undertook the competency profile to better understand what it is that agents do all day. And we recognize that it is not just what a lawyer might do. It is not just what a technical expert might do. Trademark agents and patent agents come from all sorts of areas of expertise, come from all areas of training before they go and do the exams. What is it that unites them? What is it that is shared? What is it that we would expect as an entry-level standard today's Canadian patent agent or trademark agent to know? And once we have that, that helps inform how we regulate, what kind of pathways to education might be available, what continuing professional development requirements might be necessary, what kind of training should be made available generally, what kind of standard might impact if somebody has a complaint levied against them. And so this is a really key foundational piece that we're going to talk about. But it's also, just as we start here, a really important piece for those of you who are sitting there as apprenticeship in their apprenticeships, trying to understand what the future holds for you and what it is that we're going to be examining on in the future. And so with these new clear competencies delineated for you, you have a clearer map. So I'm thrilled that we've done this important foundational work. Lots of the heavy lifting was done well before I arrived. So the accolades go to people like Jen and Leonora. And I'm going to pass it to them now so that they can get into the meat of what a technical competency profile really is. Thank you so much.
Thank you so much, Judah. And thank you, Carol, for the introduction. So we're going to be covering a lot of information during today's session. To begin, we'll define a technical competency profile, explain what it is and what it is not. We'll provide a brief overview of the process that was used to develop and validate the profiles. Leonora will examine how the performance criteria and knowledge concepts in each profile fit together, with a special focus on the strategy domain. And finally, Leonora and I will discuss how the competency profiles can be used by trainees, training supervisors, and all licensees. So to begin, a competency profile is a set of competencies that an individual needs to do a particular job. And competencies are knowledge, skills, and attributes that are needed to perform an activity to an accepted standard, each expressed as a short sentence that defines what a competent practitioner can do. The technical competencies describe what an agent needs to be able to do in order to carry out the tasks to protect a client's IP interests. Here are some examples. Note that the performance criteria listed here are just one example for each. The competency profiles provide a full list of performance criteria expected for each competency. The footnotes also provide a significant amount of information and context, and Leonora will provide some additional examples on these footnotes later on. So the examples on the screen, on the patent agent side, we expect all patent agents to be able to draft a patent application. That is the competency. And a performance criteria in order to be able to draft a patent application would be to draft claims of multiple claim types with proper scope, characteristics, and structure. On the trademark agent side, we expect trademark agents to be able to assess the registrability of a trademark, and a performance criteria for that competency would be able to assess distinctiveness. There are other types of competencies and competency profiles relevant to the practice of an agent. Professional competencies, for example, are essential to many disciplines. These more universal competencies often relate to such areas as ethical behavior, problem solving, and communication, just to name a few, and ensure that the deliverable, the IP product, is actually delivered in a way that works for the client. The current profile document includes a page on professional competencies, and we will be building this out further starting later in 2023 and early 2024. So subject matter competencies include knowledge in specific subjects, such as areas of science, engineering, and/or business, relevant to serving specific clients in which an agent may be proficient. Those types of competencies are not in scope for CPATA's competency initiative, though they are important to support various types of practice and client needs. Other than the actual content itself, the most important component of creating a competency profile is the process. Over the next few minutes, I want to highlight some of the key aspects of the process, which demonstrates that the profiles are representative of what patent agents and trademark agents are expected to do. The first component that I wanted to discuss was the robust level of licensee participation in the drafting and development process. This was critical to confirming that the knowledge concepts, competencies, and overall expectations that are presented in the profiles make sense and resonate with practitioners. We had over 20 practicing licensees participate in the development working groups. The working groups were selected to be representative of the diversity of the profession and include diverse perspectives. The second component related to bilingual equivalence and the translation process. It was incredibly important that the competency profiles meant the same thing in English and in French. 7 bilingual practitioners were recruited to review the translations and to identify potential issues with the French language translation or other cultural matters. The third component involved internal consultation. Before the large-scale validation survey was conducted, the board, all CPATA committees, and exam board members were invited to review the knowledge concepts and the competencies. The feedback that we received during the translation review and internal consultation processes were reviewed with the working groups, and edits were made as needed. The fourth component was the profession's opportunity to provide feedback and validate the work of the subject matter expert working groups through the external validation survey. This online survey was open for about a month, and all classes of licensee were invited to participate. The validation survey was set up to capture data regarding importance and criticality for various knowledge concepts and competencies. The source data needed for the validation calculations required individual licensee submissions. For this reason, it was important that the consultative components were focused on obtaining feedback directly from individual licensees. The data from the surveys was used to validate the profiles and determine if, based on the respondents' perceptions of criticality and importance, whether any edits or changes were needed before being presented to the registration committee and to the board. At their December 2022 meeting, the registration committee considered all of the background information and the reports and approved the competency profiles for the purposes of setting the standards for the evaluation of the competencies assessed by the exams. They agreed that the profiles should be reviewed every 5 to 7 years or sooner if needed to capture changes in practice. Subsequently, at their March 2023 board meeting, the board was presented with the profiles and the process development and validation information and moved to adopt them as recommended by the registration committee. The key takeaway from a process perspective is that an evidence-based professional regulation approach was applied, which incorporated best practices for psychometric defensibility, and we sought licensee participation and feedback at multiple points along the way. So I'm going to hand it over to Leonora to discuss how to work with the competency profiles.
Thanks very much, Jennifer. Hello, everyone. First, I'd like to give a shout out to many of our colleagues who devoted considerable time and expertise to the various stages of developing these profiles. They really put in a lot of time, and we're grateful to them for that. You can view the competency profiles on the CPATA website. They're available both in English and French. There was a link in the document in the webinar announcement to this document, and another is included at the end of the slides for this presentation. Now, the competency profiles contain a lot of detailed content, and I won't be going through them page by page today. Really what we want to do is to explain the different parts of the competency profiles and how they work together, so that by the end of this webinar, you'll be in a position to navigate the profiles yourself according to your practice needs. The other thing I want to say is that the profiles for patent agents and trademark agents were developed in parallel using the same methodology. So they're structured in the same way, but with different discipline-specific content. So the first thing that you'll see as you start reviewing the profiles is something called foundational sources. And these are the legal instruments and references, the manuals, practice manuals, et cetera, that agents must know and be able to navigate to practice in the discipline. The primary sources are the Canadian sources, including the relevant act and regulations, the relevant CPO practice manual, international treaties as incorporated into Canadian law. On the patent side, that's the Patent Cooperation Treaty. And on the trademark side, the Nice Classification of Goods and Services and case law. Secondary sources are the relevant international treaties and guides, including the Paris Convention, which is in both profiles, since that is the original source defining IP rights and convention priority. And the third group, which is in both profiles as well, are the professional sources, the CPATA Act, regulations and bylaws, and the Code of Professional Conduct. Moving on to the next page. Knowledge concepts are the definitions and legal doctrines or tests that competent agents need to know to practice effectively. The knowledge concepts are defined in the sources. For example, the definition of an invention or if a trademark is defined in the relevant act, and that definition may be further refined by the case law. So right after the sources, there's an initial list of foundational knowledge concepts. And this grouping of knowledge, actually quite long grouping of knowledge concepts in each profile, are the knowledge concepts that apply to multiple competencies or areas of work across a discipline. Additional knowledge concepts may be specific to a particular competency, and these are listed within that competency. Moving on to the next slide. The competencies themselves are set up as skill sets or groups of tasks. And as Jennifer has already mentioned, each competency has a list of specific tasks called performance criteria that would be performed in that skill set. As already mentioned, any additional knowledge concepts specific to tasks in that competency are included at the end of that competency. And Jennifer alluded to this as well. I also want to mention that throughout the document, there are very detailed footnotes which provide clarification or expansion of terms of art used in the knowledge concepts and the performance criteria. These really are a glossary, and when we were initially putting this together, they were a glossary at the end, but it's much more convenient to have them as detailed footnotes throughout the document. So they are important, and you should pay attention to them when you're reviewing the profiles. So let's review specific examples, starting with the patent agent competency profile. So this, as we said, this begins with the foundational sources and the foundational knowledge concepts. Primary sources on the patent side are the Patent Act and rules, the MOPOP, the legislation enacting the PCT rules in Canadian law, and the relevant case law. Secondary sources are the relevant international treaties and guides, such as the Paris Convention, the Patent Law Treaty, and the Patent Cooperation Treaty. The foundational knowledge concepts cover types of IP protection, nature of an invention, including subject matter, novelty and anticipation, obviousness, patent scope and infringement, the fundamentals of patent requirements and processes, and claim types and formalities. And then these are in turn, sorry about that. There are 5 competencies. Develop a client-centered patent strategy, develop a patent application, prosecute a patent application, assess validity of a patent, and assess infringement of a patent. So each competency has its own list of performance criteria or tasks that a competent agent should be able to perform, along with additional specific knowledge concepts. So as an example, let's look at drafting a patent application. There are 5 associated performance criteria for this competency. Identify, given a set of facts, claim drafting objectives, draft claims of multiple claim types with proper scope, characteristics, and structure, describe an invention, including its embodiments and alternatives, and plan the drawings that illustrate the features of an invention. And you'll see that there are footnotes associated with 3 of the performance criteria, which I've highlighted. And let's have a look at those. So identify, given a set of facts, claim drafting objectives. Well, these claim drafting objectives should reflect the innovation context and a client's goals and objectives, and they should aim to clarify the breadth of the protection sought. In the case of drafting claims of multiple claim types, you'll see the list here in green is quite expansive, quite lengthy, but we mean both independent and dependent claims, but also different different species of claims, such as product claims, apparatus claims, method claims, and specialty claims, such as improvement claims, Marcouche group claims, etc. And drafting claims with proper scope, characteristics, and structure refers to drafting claims that, one, meet the requirements of the Patent Act and rules, and they reflect claim drafting objectives, including the prior art, and they have a logical organization. In other words, we have the product claims all cascading in one group, and then maybe process claims in another group. They follow a logical order. Describe an invention, including its embodiments and alternatives. So this has invention means as defined in Section 2 of the Act, but it also includes its embodiments and alternatives. And finally, there's a list of knowledge concepts specific to the performance criteria in this competency of draft a patent application. And these are in addition to the foundational knowledge concepts. And so these are very specific. Most of them are specific to claim drafting, but you'll see the third knowledge concept is specifically the content of the disclosure, the elements required by the Patent Act and rules. The fifth element, mirroring claim language in the disclosure. And the last element are the procedural rules respecting acceptable drawings and labels. Moving on to the trademark agent competency profile. Again, we start with the foundational sources and foundational knowledge concepts. The primary sources are the Trademarks Act and rules, the TMEM, CPO practice notices, the CPO goods and services manual, that is the NICE classification in Canadian law, and the relevant case law. Secondary sources are the relevant international treaties, including the Paris Convention, the Madrid Arrangement, and the NICE classification. The four major task groups or competencies are assess the registrability of a trademark, develop a client-centered trademark strategy, prosecute a trademark application, represent a client before the Trademark Opposition Board in opposition in Section 45 proceedings. And each of these competencies is in turn broken down into discrete skills or performance criteria relevant to the competency, to the task grouping. So moving on to the performance criteria associated with one of the competencies, assess the registrability of a trademark. You'll see on this page, we have 7 of 9 of the performance criteria. And I'm just going to stop because that's the only joke you're going to get. This is, of course, my allusion to Star Trek, 7 of 9. The seven on this page are plan a trademark search, interpret search results, assess distinctiveness, assess likelihood of confusion, assess descriptiveness, assess entitlement to registration, identify, given a set of facts, potential areas of conflict with third parties. So 2 of these, 5 and 6, these performance criteria have associated footnotes. Let's have a look at those. Descriptiveness, as we know from Section 12, includes an assessment of misdescriptiveness. An entitlement to registration refers to who may register a mark, as set out in Section 16 of the Act, with consideration of prior rights and priority claims under Section 34 of the Trademarks Act. And then the other 2 performance criteria identify, given a set of facts, prohibited marks, which is any mark prohibited by the Trademarks Act, including those listed in Sections 9, 10, and 10.1, and identify, given a set of facts, potential technical objections. So technical objections really are non-substantial objections to barriers to registrability, which would include deficiencies in the formalities. There are 2 associated knowledge concepts that are specific to assess registrability of a trademark in addition to the foundational knowledge concepts. And they have multiple footnotes, clarifying footnotes. Registrable trademarks, obviously that's what's defined by Section 12 of the Trademarks Act. Searches, this is a big area. Search-related knowledge, that concept refers to awareness of the parameters and processes of searching, where and how to obtain quality search reports and how to interpret them, how to use online databases, what fields are searchable, and how to use and combine Boolean operators and wildcards to construct multi-level search strings. Trademark status, the marks that you locate in a search, obviously that's a very important knowledge concept. So that would include understanding whether a trademark is pending, registered, abandoned, expunged, canceled, or withdrawn, and the effect of that information on your search results. And search results limitations, risks associated with search, the limits of the scope of a search, and unknowns that are relevant to a trademark search. So the other thing that we wanted to do was to discuss this new skill set or competency, develop a client-centered strategy. This is included in both profiles, although with different discipline-specific content. You'll see that the definitions from the profiles are quite parallel, I would say. A patent strategy would be a strategy to maximize client's position to achieve its goals and objectives by protecting the innovations and the client's freedom of action. A trademark strategy is a strategy to adopt, use, register, or protect a trademark to assist the client to achieve its goals and objectives. And clearly, these are very client specific, and they are going to, they're not necessarily going to be performed in every situation or in the order set out in every client situation, and will really depend on the needs of the client and the experience of the agent, what exactly is applied. The reason that we have these, we'll go back a slide there, Jennifer. The reason that we added these client-centered strategy competencies is in developing the profiles, the subject matter experts realized that that they could really bring a benefit to the profiles, something above and beyond what the exams had traditionally examined on, by adding a focus on strategy. And so based on and a lot of this is based on their experience working with clients and coming together to bring that experience together. So the strategy competency, as I said, is quite nuanced, and it will vary depending on the needs of the client and the experience of the agent. It covers a wide range of performance criteria, from basic analysis and advice that an agent would normally provide in initial meetings with a client, and really is something that any entry-level agent should be able to provide. At the other end of the range are complex strategic advice for maximizing the client's IP protection across multiple facets of its business. So as I said, basic analysis and advice requires knowledge and understanding of deadlines and the basics of protection. And this is entry-level competency. The more strategic thinking comes from experience and further study, and it's the higher level of performance we all aspire to by improving our abilities as professionals and counselors. And so I do think that the strategy focused competency is something that will benefit the entire profession from entry level, but more experienced licensees as well, to help them to aspire to improve their practice. Let's look at some examples from the two strategy competencies. This example is competency profile, and it shows how performance criteria for the strategy competence combines basic analysis and advice with a more complex bent. So the performance criteria outline, given a set of facts, practical and strategic timelines. So practical timelines would be deadlines for entering national phase for PCT applications. And when we look at the foundational knowledge concepts, a relevant concept here is key patent office activities and statutory deadlines for Canadian and PCT practice. Strategic timelines, the example in the footnote in the performance criteria, is staging of separate or related inventions to optimize the client's expense timing. And when we look at the foundational knowledge concepts, the concept of the effect of key patents, treaties, and international programs is relevant here. Which treaty do we use? Is patent cooperation treaty the way to go? Is another program like a patent prosecution highway, is that a way to go? And if I choose the latter, is it better for my client to go with a jurisdiction that will deal very expeditiously with the application and allow me to get my patent issued in the reciprocating jurisdictions very quickly? Or do I go with a jurisdiction that's maybe a little more leisurely in its examination, which means that I can push out, or the client, I should say, can push out the expense associated with obtaining patents in the reciprocating jurisdictions. So these are, you can see there's different levels of strategy and different levels of experience required for each of these. Moving on to the next slide. This is another example from the patent side, which is assess the innovation context. And here the footnote really demonstrates the experience of the subject matter expert working group. You know, what is the innovation context? Well, we mean the technical field or area, scope, state of the art, environment, business client, business context in which an invention will be publicly used, including any constraints and appreciation of which supports an agent's ability to recognize an inventive step and produce practical advice. Moving on to an example from the trademark competency profile, or actually two examples. One performance criteria in the strategy competency is identify, given a set of facts, available types of intellectual property protection, including types of trademarks. Types of trademarks are standard, character trademarks, design marks, non-traditional marks, certification marks, official marks, geographic indications, and unregistered trademarks. And this is something that, in my view, an entry-level trademark agent needs to understand. If a client walks in, you need to be able to understand what is the type of trademark. Is my client, could they possibly be entitled to obtain an official mark? Should they be looking to obtain a certification mark or a geographic indicator? That's entry-level knowledge of trademark types and how they apply to different applicants. More complex would be identify, given a set of facts, strategies for rendering a mark registrable. So faced with a mark that potentially will have substantive barriers to registration, what can I advise my client to do in order to overcome those barriers to registration, possibly adding design elements or removing goods and services in the case of descriptiveness, or commencing use in order to obtain distinctiveness. So in summary, the new strategy competency in each profile augments the other competencies, providing a developmental path from providing fundamental or basic strategic advice to being able to provide more complex strategic advice. We'll just move on to the next slide. And I think here, Carol is going to give the CPD code.
Well, thank you, Leonora. In compliance with CPD accredited provider rules, IPIC is required to issue a code during the webinar. The code is FIR30, and again, that's FIR30, Frank Indigo Romeo 3-0. There you go.
And then I think we're turning it over to Jennifer.
Thank you. Thank you so much. All right, so let's talk a little bit about what the competency profiles mean for the profession. We're going to use the competency profiles to train and prepare for the qualifying examination, but there's also relevance to all licensees. So the million-dollar question, I'm sure what everybody who's currently training wants to know is, what does all of this mean for a trainee? Well, as a starting point for everybody, all trainees, whether they're just starting their training, in progress with their training, or have completed their training, should read the competency profile for the license that they're pursuing very carefully. The new qualifying exams, oh, there's a typo there, that should say align with the competency profile. And that includes the knowledge exams and the skills exams. Those will be administered in 2024, and we'll talk about those a little bit more in a few slides. But there's really three groups of trainees that this will impact. The first scenario includes trainees who have completed their training and they're in progress with the exams. So your first option is to attempt the 2023 exams and try to get through those at the final administration of the legacy exam regime in the fall of 2023. And option two would be to transition to the new exams that will start with the knowledge exams in March of 2024. In all cases, if you're going to be transitioning into the new exam process, I would definitely recommend reviewing the competency profile, identifying any gaps in knowledge or skills, and then complete additional training or education to bridge those gaps prior to attempting the new exams. It's important to note that there will be no carry forward of previously passed papers or parts into the new exam regime. The second scenario would include individuals who are currently in progress with their training. So maybe you're not eligible for the 2023 exams yet, but you will be starting the exam process in the new formulation that we'll have set up. So for individuals that are in progress with their training, I also recommend reviewing the competency profile with your training supervisor, identifying gaps in training and knowledge, and completing the training in identified areas during the remainder of your training period. Finally, for individuals who haven't started their training yet, obviously review the competency profile with your training supervisor and develop a training plan that aligns with the competency profile for your 24-month training period. And then finally, you would attempt the exams upon completion of that training period. Now, what does this mean for training supervisors? As with the trainees, supervisors should also carefully review the competency profiles and review them with your trainees to develop a training plan that will allow them to learn and practice the knowledge and skills necessary to provide patent and trademark agent services. Some training environments may not cover all of the areas that are included in the profiles. Now, that's okay as long as you can work with the trainee to identify how those gaps will be bridged. For example, could the trainee be seconded for a period of time to receive exposure to something that your practice currently doesn't do? Or is there an external course or program that they can attend to obtain that knowledge or learn that skill? Now I'm going to hand it over to Leonora and ask how she would use the competency profiles to inform a training and exam preparation plan.
Okay. Thank you, Jennifer. Right now, their garbage trucks just decided to come outside of my window here. I apologize for the noise. Yeah, we thought that it would be very helpful just to give you an example of how you might use the profiles to develop a training program and to prepare to write the exams. I just want to be clear, this is my perspective. It's not prescribed by the college. It's simply based on work that I've done in both as a patent agent and as a trademark agent over the years. And it's based on a well-known developmental approach to professional training, which progresses through three learning areas, I guess you could say. The first is remembering and understanding, which is learning the fundamentals of the discipline. Secondly, analyze and application of the fundamentals in new, but generally routine scenarios. And then the third, the highest level of learning, is knowledge utilization and problem solving in unique or more complex scenarios, and working with increasing autonomy. So I think that the way that the profiles ended up really works well with this three-stage approach. In stage one, the licensee should learn, or I should say the trainee should learn and be able to articulate the foundational knowledge concepts as defined in the sources, particularly the primary sources. So in the case of a patent, what's the definition of statutory subject matter, test for anticipation and novelty. And on the trademark side, definition of a trademark, test for confusion. And although we didn't show them the foundational knowledge concepts, it's really quite a long list in each case. And if one were to go through and learn all of that and find out what is the appropriate definition or test in the statute and has been modified by case law, you would really come away with a very thorough foundational knowledge. This is something that a supervisor could require the trainee to do, but the trainee could just start doing this work on their own as soon as they decide to enter into training. They could be working on acquiring the foundational knowledge of the discipline. In stage two, The trainee can practice applying those foundational knowledge concepts and any additional relevant specific knowledge concepts to performing easier criteria such as analyzing and evaluating fact scenarios and revising existing documents. So for example, on the patent side, assess prior art citations and draft responses to office actions, draft claim amendments, assess anticipation and novelty. So as you can see, working with an existing application or an existing patent in order to apply those knowledge concepts. On the trademark side, perform and analyze registrability searches, draft statements of goods and services, draft responses to office actions. Again, working with existing documents and really helping to really applying those knowledge concepts. On stage 3, as the trainee becomes more proficient, both at their knowledge of the concepts, but also in drafting in the appropriate way for patents or trademarks, then they should start doing more independent work. So working with a supervisor, meeting with a client, and drafting, taking their hand at drafting independent claim and cascading claims of varying scope based on the client's description of the innovation, assessing obviousness, assessing an infringement, and planning a patent filing strategy, working with increasing autonomy, initially heavily supervised, but by the end of the training process, hopefully able to sit down, draft a patent application, and review the final product with the supervisor. On the trademark side, more complex tasks would include preparing evidence and argument in opposition or Section 45 proceedings, and identifying practical ways to manage a portfolio of domestic and international trademark protection. So that's really just my view, and I'm going to pass it back to Jennifer to talk about the exams.
Thank you, Leonora. So those of you who are in your training program or who are going to be transitioning into the new exam process, you're definitely going to be interested in understanding and knowing about the test specifications. So each qualifying examination is being developed using a set of test specifications, and those outline what an exam will measure in terms of content domains. So it'll provide information about areas and weights, as well as guidelines on how the content is to be measured. Such guidelines are expressed in terms of structure, so it will be able to tell you format, length, the cognitive levels that we're going to be testing at, and context. So for example, the circumstances in which examination questions are framed that can influence their interpretation. The exams will be aligned with the expectations in the competency profiles. Bearing in mind specific goals and constraints, the content weights for the qualifying exams were set by a group of subject matter experts made up of practicing agents and guided by a psychometrician. These weights were informed by the large-scale competency validation survey, which was administered last fall. The test specifications were presented to the registration committee at their March 31st meeting and have just been approved and translated. They're now being prepared for publication and will be shared with the profession as well as all trainees and exam writers as soon as that publication is ready to be posted and circulated via our newsletter. So a little bit more on the examinations. The knowledge examinations will be administered in March of 2024. The purpose of each of the knowledge examinations, so there's a patent knowledge examination and a trademark knowledge examination, is to ensure that trainees have the foundational knowledge necessary for practice in the relevant discipline. The knowledge examinations use a multiple choice format. Specifically, each examination consists of 135 independent multiple choice questions that include 4 response options. This format was chosen for the knowledge exams for several reasons. Selected response items, such as multiple choice, are an efficient means of gathering information about a wide range of knowledge and competencies. Because such items can be answered relatively quickly, a broad range of content can be covered in a short period of time. These items are easy to score both accurately and consistently. For an examination consisting of 135 independent, concise, multiple choice questions with 4 response options, 3 hours would typically be adequate for most candidates. However, given that time pressure is not a tested construct on this examination, and given accessibility goals, the time to complete the examination will be 4 hours. The registration committee is responsible for setting the standards for passing the examinations. They are currently considering recommendations from our psychometrician regarding the cut score approach, and more information regarding scoring will be available in the coming months. So candidates who are successful on the knowledge exams are then eligible to attempt the skills exams. And the skills exams will be administered for the first time in the fall of 2024. The purpose of the skills exams is to ensure that trainees have the skills necessary for practice. These exams are computer-based written response format, and this format was chosen for several reasons. Constructed response items allow candidates to demonstrate more in-depth or complex competencies, as there is no pre-drafted response to select. And performance-based tasks can also be used to assess the ability to integrate or translate competencies into effective performance in practice. These tasks support assessment at a dimension of depth not available through other formats. The skills exams are expected to focus on the highest impact core competencies as identified through the validation and test specification work. Because the multiple choice exams, or the knowledge exams, cover the underlying knowledge concepts, the skills exams can concentrate on higher order cognitive aspects and core skills. Agents have been recruited to assist with developing the general recipe or instructions, rating scales, and the wording for the specific question parts or prompts of the new skills exams. Using these recipes, we will be developing sample exams with content from previous years. This is being done so that candidates can have a better understanding of how the new exams will work and what they will test. So the sample exams will hopefully be ready for publication later this year in anticipation again for the fall 2024 administration. The last slide that I have on this topic would be how the current exams compare to the new exams. The exams are comparable in terms of testing time, with there being slightly more testing time on the trademark side as compared to the legacy exams to account for the knowledge exam component. Maintaining the same approximate testing time avoids introducing additional barriers to entry. While there are several high impact changes between the new and legacy exams, there should be a sense of familiarity between the two approaches. The content coverage is comparable with nothing of significance lost. And as Leonora discussed earlier, there really isn't anything new about what's being tested. The changes really have to do with how things are tested, in what proportion, and at what level. So I'll hand it over to Leonora to discuss the competency profiles and relevance for all licensees.
Thanks very much, Jennifer. So this is really final thoughts. We've talked through the structure of the competency profiles and how they might be applied to develop a training program and to prepare for the examinations. The profiles are intended for the entire profession. They set out the entry-level competence requirements, and Jennifer has described how the new exams starting in 2024 will reflect the profiles from testing foundational knowledge in the initial screening exam to specific skills in the skills exams. The profiles also provide a methodology for keeping the skills of full licensees current, whether through ongoing enhancement and CPD or assessing one's suitability, for example, for job interviews or promotions. The new bylaws, which were effective yesterday, May 1, include provisions for returning to active practice after a hiatus. A risk-based approach will be used to analyze each applicant's unique situation, particularly where the absence has been lengthy. A relevant competency profile will provide guidance for determining whether skills upgrade is advisable as a condition to return to active practice. And finally, the profiles will also be instructive in connection with the Code of Professional Conduct, particularly the competence and quality of service requirements. I'd just like to mention that there is right now a new article that is about to be published on the CPATA website that discusses more the association between the competency profiles and the and the Code of Professional Conduct. So I urge you to have a look at that when it's published, and it will also be in an upcoming newsletter. And I think with that, we're ready to open up to questions.
I have to unmute myself. Thank you very much to the speakers. That was very helpful, very important information for everybody. We have quite a number of questions. And I think what I'll do is start with the ones on the subject matter and then go to the more general questions. So the first question then is, there have been significant recent technological advancements with large language models, or LLMs, such as ChatGPT. These general availability of these technologies are likely to trigger major changes in patent practice. Are there any plans to introduce a competency profile relating to the use of technology by agents? The LSO has considered this in their quotes using technology guidelines. However, those are not a requirement, but only a recommendation.
I can take that question
Thank you.
I'll start with that. At this point, the profiles are set the way they are for the time being. If it comes to the registration committee's attention through the board, that something like this needs to be considered sooner than the 5 to 7 year cycle that we kind of have set out for the revisions and review of the competency profile, then we would include them possibly at that point. And it also might actually come up during the development of the professional competency profiles later this year. There might be a section related to the use of technology as well. So we'll have to kind of see as things unfold if it seems like it will fit better within the professional competency profiles slated to start later this year, or if it's more technical and discipline specific, if it should be included in the next iteration of the technical competency profiles.
And I'll also add something to that, not specific to this technology, but as I was preparing for this webinar today, one of the things I noticed that was very significant, had an impact on me, was the difference between searching, on the patent side for novelty and obviousness, and searching on the trademark side. And on the trademark side, this is reflected in the competency. I mentioned it when I was going through the assess registrability of a trademark, that the technology associated with trademark searching, image recognition, all of that has improved tremendously over the last 5 to 7 years. And therefore, trademark agents are considered, according to the competency, they should have a competence in performing trademark searches. Whereas on the patent side, it is different. I don't believe that patent agents themselves generally perform the patent searching or the entirety of the patent searching themselves. So as Jennifer said, I think it depends on how these things develop, and whether that will be something that in the future a competent patent agent or a competent trademark agent should be able to work with.
Okay, we have a question regarding the new client-centered requirement. What is CPATA's recommendation where a client wants something that the patent agent does not believe will maximize a client's position?
So, I mean, I don't believe that this is any different than any other profession. I think that this happens to lawyers as well. I'm sure it happens to trademark agents as well. And it's a discussion with the client. I don't, obviously, if the client refuses to take advice from the professional, that's a discussion between the professional and the client. I don't, and I hear, Judah, I don't know if you have any specific comment on this, because I do think it's broader than just patent agency.
No, I think that's right. And I think Leonora's got the 101 on that. Going back to my old risk management days and old technology, I used to liken these sorts of discussions to those with the CD player, communicate document. So you need that conversation, but if it's a contemporaneous chat, you want to confirm those instructions in writing, so that if you said to somebody, this approach is not going to go well, then you have that. And that helps reduce complaints or the likelihood of a complaint, or in the event that a complaint is received either by a regulator or with respect to professional liability, there's a paper trail that's more or less contemporaneous that helps reduce your risk as well. So everyone's on the same page. Those conversations do happen. They just need to be documented as well.
For those who attempted the fall 2023 exams, when will the exam results be provided? And specifically, will they be provided sufficiently in time before March of 2024?
That is a great question, and it is our hope, our scheduling plan to have those results released by late 2023. So hopefully before the holidays in 2023, which will give us sufficient time for the recorrection process to occur in early 2024 and the recorrection decisions to be available prior to the March 2024 knowledge exams. So that is the tentative schedule. Hopefully all goes as planned, but we are hopefully going to be able to deliver those results well in advance of those exams. And that's particularly why the exams were pushed up by a month this year. And the trademark exams are being written in September and the patent agent exams in October to accommodate for the new knowledge exams in March.
Thank you, Jen. Will CPATA be publishing a model training profile or plan? I'm not thinking of something mandatory, but rather providing a tool or example for the development of a customized training plan. Or if not, is this something that it might be useful for IPIC to take on? And certainly IPIC's prepared to provide that kind of information, but I would think this is something that really should be coming from CPATA. Do you have any plan to do that?
At this point, we're still looking at various resources to develop to support agents and trainees through understanding the competency profile and what a sample plan or training plan or education plan might look like. And in those resources, it'll probably be similar to something that Leonora presented today in terms of kind of walking through the stage 1, stage 2, and stage 3 knowledge concepts and then skill sets. So we are looking at various resources to complement the profiles, which will be published hopefully this year.
Okay. Given the rapid advances in AI, what is CPATA's plan for protecting the public interest against encroachment of AI into patent and trademark practice areas such as advice giving, document preparation, patent drafting, etc.?
That's an excellent question, Carol. It's not a policy issue that the board has considered yet, but one thing I would point to is that the board has adopted regulatory objectives. And one of the, there are tensions in it. One of the objectives is to protect the public and ensure and promote the ethical and competent delivery of those services provided by agents. And so to the extent that technology helps trademark agents and patent agents to do the work, that's an important factor. But if the question is about us taking steps to try to curtail the use of AI by, for example, individuals using those tools to act on their own behalf, the objectives also state that our objectives are to promote innovation in the delivery of services, but also to improve access to and promote competition in the provision of patent and trademark services. And so it remains to be seen how the board might look at those. But speaking personally, I'd be surprised if we were to lead a charge against the use of technology.
And sorry, I just wanted to add one more thing. I mean, on the patent side, maybe on the trademark side as well, machine translation for foreign counterparts has been used for a long time. But at the end of the day, the agent who's actually putting their name to file the application, the counterpart, they have to be confident in what they're filing. And so to the extent, I mean, just to echo what Judah is saying, to the extent AI helps with drafting, that may be a good thing, but it's the agent who's responsible that it's done competently.
Okay. Will there be any exam sample for the knowledge exam?
We are hoping to be able to publish a couple of sample exam multiple choice questions for the knowledge exams, but they'll be pretty straightforward in terms of what multiple choice exam questions look like. And in terms of content, it really is based on the knowledge concepts that are identified in the competency profiles. So as I mentioned, we will try to publish a handful of sample exam questions for the knowledge exams, but we're really focusing our energy on creating sample exams for the skills exams, because I think that's really where individuals who are currently in the exam process or even new trainees and new candidates will want to see and understand the differences between the previous legacy exams and the new exams, and kind of what to expect on those new skills exams, because those are the constructed response written answer questions.
Okay. If a trainee is eligible to take the qualifying exams this fall in 2023, do they have to take the legacy exam offered this fall, or do they have an option to forego the legacy exam and take the new exams in 2024 instead?
That's a great question as well. And individuals who wish to not write in 2023 are able to do so. We just ask that when we send out the communication about exam registration, that you send us back a notification, an email, just letting us know that you wish to not write in 2023 and you wish to write in 2024, so that we have that information on file. Otherwise, there won't be any requirement to write in 2023, with the understanding that, as I mentioned before, and as we communicated starting last year, there is no carry forward of previously passed parts or papers.
Sorry. There's an interesting question in here, trying to get to all of them. Do you expect the pass rates for the patent and trademark agent qualifying exams to increase, decrease, or remain the same?
Well, that's a really good question as well. And I think that only time will really tell in terms of what the outcomes will be. CPATA doesn't have a specific pass rate in mind. We don't have, we want to pass a certain number and then not pass a certain number. As I explained, the cut score methodologies are currently under review by the registration committee, and those will be based on psychometrically defensible approaches to cut score setting. But other than that, our hope is that the pass rates will increase as the competency profiles are starting to be integrated into training plans and education plans, and as we are able to provide more transparent information about the content and the structure and the context that the examinations are going to be written in. So again, our hope is that the pass rates increase, but as I said, we don't have any specific benchmarks set at this point.
Okay, we have a question about the fees. Prior to the bylaws being sent to the government to be gazetted, there was advance notice of the change of classes on the college website. Why was there no advance notice or consultation with respect to the increase in fees, particularly when you've told us the college would be transparent, fair, and welcome input?
Thanks, Carol. I think that the key issue here about transparency is that we announced the fee increases months before they come in. We wanted to give licensees as much time as possible to prepare for the increase. The real question about that I've also heard, though, about the fees is around why did we not consult on that issue about the fee increase? And the answer is that it has been clear for some time from CPATA's perspective that we do not have the budget needed for the go forward, that the amount that was initially picked to start the college was not enough to sustain the college. And when we consult for areas where we need input. Here, this was not an easy decision, don't get me wrong. This was a very difficult decision for the board, but everyone on the board knew that a fee increase would be difficult. Everyone on the board knew that fee increases are not generally widely accepted or celebrated by those who have to pay them. But I will say this, unlike other areas where we have openly consulted, where we need that input around the technical expertise of the profession, and where the profession thankfully has been extremely generous in their time and in providing their support, regulators do not typically consult on fees. Law
Well,
societies.
actually, I'm not sure that's right, Judah, because
So Carol, if I could please finish, the Law Society does not consult on fees. They do not open a public consultation every year that fees are set. They have never done so. Consultation on fees among those who are regulated and required to pay them is not general practice among professional regulators. So no, we did not consult on fees. Typically, professional regulators do not consult on fees. We know that an increase will generally be a cause of consternation, but when it came to our statutory obligations and the things that Parliament has asked us to do, and that Parliament has instructed us to do, this board modeled through and realized that we needed to increase fees.
Okay, well, there's a couple of problems with your answer. First of all, there's no disclosure of any of the internal discussions. And so when you say you need them, there's no evidence that they're needed. That's the first problem. The second problem is your answer suggests there is no expertise out there with respect to fees. And I don't see how you can possibly say that when you have a number of people in the profession who run businesses. They know how to keep
Carol,
costs.
with respect,
sorry, you asked me to let you finish, you let me finish. So they know
Carol,
how
the
to
question
keep costs
was not
down,
to you.
and so do IPIC. IPIC also knows how to keep costs down. They run an office, smaller, bigger than yours, less cost. They do their translations, less cost. And so you could have benefited from the input with respect to costing had you made it public, but you chose to keep it a secret. And you can't possibly tell us that you're a collaborative organization on the one hand and then dictate fees on the other. That is not collaborative.
Well, Carol, I think we're going to have to agree to disagree or just plain disagree on where a modern independent regulator will go to a regulatory association for advice. We have an appointed board of 5 and an elected board of 4 who are there to provide input from the profession, and I can assure you they did, about the costs consequences. But if you're asking to receive advice and for us to take advice from IPIC about our line-by-line budget, I can tell you that's off the table. We have accountants on our board. We have heads of legal departments on our board. We have a competent board. We have competent staff, and we will run the operations. But what I can tell you is that we're getting complaints, and we don't have a reserve, and we don't have anywhere near the budget of the regulators who people have been writing in about groups like engineers with a fee that's only a few $100s, but they have a $35 million budget. The law societies with $100 million budgets. Our budget is currently under $2.5 million, including startup costs. But on the go forward, we're getting the complaints that regulators are expected to get, and we have to address them. So Carol, I think we should leave the discussion on this point for now.
Okay.
Because the question was asked and I've answered it to the point where I'm comfortable with. But today's session was really to show where some of the work has been going. And there's been a lot of questions about the importance of this competency profile that did not exist before. And this is the work that we're doing. This is the important work that signals to the public what patent agent and trademark agents do, so that those who wish to enter the profession know what will be expected of them and what consumers can expect from them as well.
Okay, well, we certainly disagree. So one of the questions, though, and apropos of the comment that you have just made, is with respect to complaints. When you're talking about complaints, the question was, are the hearings only for agents who are not lawyers? My understanding is that if there is a complaint for an agent who is a lawyer, their complaint in hearing would be with the law society of their province.
That is not necessarily the case. It will depend on a variety of factors as to whether a complaint about a lawyer could end up in our tribunal. But I can tell you this, when we get a complaint about a lawyer agent, we are duty bound to investigate it. It may be that we tell the complainant that this is not one that we will be exploring. It may be that this is one where we say, we are not going to be taking steps, but you should, if you believe it is necessary, write to the Law Society. But there are also areas of shared interest where it's possible that there would be a hearing that would go for the lawyer for their conduct. And then in turn, we would also have a hearing with a conduct determination. Areas such as criminal behavior, for example, might give rise to separate hearings because we would need to take discipline at both sides. And so the answer is no, we have a pretty broad net. And as the complaints come in, which we cannot control the pace of receipt, we have to investigate them.
Okay, and the follow-up question, how many complaints has CPATA received?
We have had fewer than a dozen complaints to date. They have been varied though, and they have varied in terms of their complexity as well.
One of the questions is with respect to bylaw section 73, licensees to advise the registrar, more specifically 73B and D. Has CPATA not considered that the requirements as listed are inexcusably broad? For example, section 73B requires licensees to inform the registrar at any time they have a judgment entered against them by a court. This could easily be, for example, a judgment regarding visitation rights for a divorced couple. Why should someone be required to disclose this type of thing to CPATA?
We drafted the bylaws in consultation with the Department of Justice. They followed standard language around duty to report that other regulators have done in the past. That is not to say that if there is a judgment entered against you in your personal life that we would necessarily take any further actions.
But at the same time, why is it any business of CPATA? Why should you get notice of that?
Carol, we're getting really off topic from the topics we were going to talk about today.
Oh, I'm sorry. I'm so sorry.
But I'm happy to continue the discussions about our bylaws more generally at our annual general meeting, which is taking place in May. And I'd encourage everyone to join us in person or by Zoom. And it will be available in English and en français pour ceux et celles qui sont bilingues, ou des francophones ou des francophones.
Oui, nous comprenons. But, and apropos of that, do you know how much time has been allotted at the AGM for questions?
The total meeting will be an hour. We have yet to determine how much time will be available for questions. But if there are questions around fees, I can assure you we'll have a presentation about fees at that time. There will be a presentation that will address our plans for the future. There will be also a discussion about the bylaw changes.
Okay, no, but I guess the question is there a certain period of time that's allotted for questions from licensees?
Yes, there is a period allotted for questions.
And do we know how long that is? That was the question.
We are going to be breaking up the meeting into different chunks. There will be a few minutes per area.
Okay. One question is, would getting government subsidies be an option to support CPATA to meet its financial obligation?
That's a really good question, and it's one that we would ask IPIC about, because IPIC asked for self-regulation back in 2016. And self-regulation requires separation from the state and would involve self-funding. And so if IPIC members believed that they would prefer to receive government funding, then that's something that IPIC could ask government to do. At the moment, the model that has been provided is a licensing model. So we would ask about that over to IPIC because it might have implications on whether a regulator is considered sufficiently independent.
Okay, so I'm just not clear on what the answer is then from CPATA's perspective. Is that
the answer from CPATA's perspective is at the moment, our sole area of funding is from licensing and exam fees and the like. The board has had some discussions about alternate sources of funding. Ultimately, there do not appear to be any available currently. And so at the immediate, the need for fees, the need for revenue led to a fee increase. But also there is a broader policy question about whether this independent regulator should ever take money from government, given that it is being set up to be independent, and given that IPIC asked for self-regulation and wanted as much independence from government to ask for solicitor-client privilege, for example. And so before we would go to government to ask for money, we would ask IPIC and licensees of their thoughts on that.
I have a follow-up question about the bylaws, and that is with respect to some of the provisions in the bylaws, like the one we just looked at, is there some reason why there was no consultation on those bylaws?
Bylaws are actually something that must be done through the federal government. When they are being drafted, they are subject to King's Counsel privilege. We are not able to disclose them. We are not permitted to share them. It is a high level of confidentiality that must apply to them. So we had no ability to do so.
But that's after you've talked to the government. Prior to speaking to the government, why was there no consultation on those changes?
On which changes, Carol?
Well, the other, I mean, you said the fees are off the table, but there are other changes in those bylaws. And so the question is, with respect to the other changes in the bylaws, things like reporting judgments, you could have given sort of at least a point form list of those changes and got input on that. You can do that before you go to the government, and you didn't.
So Carol, the bylaw, yes, I will answer that. Thank you. That's one could go and talk about the many different things that go into the bylaw, but the truth is that it is an iterative, organic drafting process that we did with the federal government, and that there were parts of our policies that got rolled into bylaw. There were parts of our policies where the Department of Justice lawyers said, you must do this a particular way versus a different way. So it was quite organic and moving in real time. The process does not really lend itself to the type of consultation that one of the kind that you're suggesting. The only other major area was fees, which I've already addressed.
Okay, I'd ask one last question because we're almost out of time with respect to the exams. And the question is, and I'm sorry if I asked it already, will you provide an exam sample for the knowledge exam?
Oh yeah, I think I responded to that earlier.
Okay, sorry, there are too many questions here. Okay, well, I think that takes us to the end. And I'm sorry, I have not got to all of the questions, and some are very specific to certain people who, where they are in the training process. So if you wouldn't mind emailing your questions into CPATA, and then probably a lot of these Jennifer will be able to answer fairly rapidly. And then that way you'll get your answer if you didn't get it here today. I don't think there was anything else that I missed. Oh yeah, one last thing, is there a provision for carryovers in the new exam structure for the skills exams?
We'll definitely be making those decisions in the coming months when the scoring approaches are decided, and we'll have a policy on recorrections and carry forward that will be published shortly. But I can say that it will work a little bit differently than it has on the legacy exams. And when we have those decisions made, then we'll communicate those out to everybody.
Thank you. Okay, well, I guess that takes us to the end. Thank you, Leonora, Judah, and Jen for a great presentation. Thank you to everyone for participating in the webinar. And we invite you to complete the online evaluation form sent via email. And we hope you all have a good afternoon.
Thanks very much again to IPIC for hosting, and thank you for having us.
Thank you.
Thank you.